Yes, Mr. Friend.
Thank you, my lords, my lady. One point of housekeeping, I discussed with my learned friend. We have both sat in the front row. We hope that's okay.
Of course.
We thought as much, particularly with the people behind us.
No, of course. And may I thank you and all those behind you for sitting early today. You won't be surprised to hear that means that we need to rise early.
Yes.
And we must rise by no later than 3:45.
I don't envisage that being a problem. I've discussed with my learned friend. I would be surprised if I'm still going at lunch, and given that indication, I'll make sure I'm not still going at lunch, so my learned friend has a fair chance as well. I would hope I may be done around 12 or just after.
Well, we've had an opportunity of reading all the papers, obviously the judgment, skeleton arguments, but we've also all dipped well into the authorities. And I have to say, I thought a day was a generous estimate in any event. So I think we should be fine.
Yes. So, my lady, just in terms of documents,
Sorry, if you could just give us 1 moment.
Yes.
I need to get my laptop on the other side for obvious reasons.
Yes. Hopefully the court will have the core bundle with the cross-reference skeletons which have been added, and I thank the court for adding those. There's then a supplemental bundle, a main authorities bundle, a supplemental authorities bundle which I don't propose to take you to, but we just wanted to make sure the court had all the authorities on Section 106 there, if insofar as you wanted to look at them. But really then the issues before us, and down below there were 2 sets of proceedings, 2 issues, 3 issues rather. My client's Part 7 to enforce the adjudicator's decision, and the counter Part 8 for a declaration on the payless notice. There was a third quite interesting issue down below as to the adjudicator's fees, but there is no cross appeal on that point. So we are left with 2 issues. Part 7 proceedings, can the defendants show they can fall within the residential occupier exception? And Part 8, did they issue a valid payless notice? And in reality, those issues turn on 2 or 3 documents ultimately where on the parties' positions. So to deal with, if I first with the Part 7 and the jurisdictional point, the court would have seen that there were obviously a larger number of arguments run down below. I don't advance all of the arguments which were run down below on this point. I confine myself principally to these 2 points on which I say the judge was wrong to decide not that Mr. and Mrs. James were residential occupiers because he didn't decide the point, but that it needs to go to trial. And the 2 reasons I say he was wrong to reach that decision were firstly the fact in terms of the development loan or loans. That is the very loans which funded the works, which in my submission are conclusive effectively on the objective test that they were not residential occupiers. That is my first point and the longer point to develop. The second shorter point is that Mr. and Mrs. James's own evidence is that they intended to, and more than that, needed to, in order on their plan to be able to pay for the mortgage, rent out this property 25% of the time on Airbnb. And I say that even if you...
Sorry, did you say 25% of the time?
Yes.
Yes, because
it's 13 weeks a year.
13 weeks,
yes, so 13 weeks a year, 52 weeks, so around 25% of the time. And I say that that evidence even accepted, and of course I can't challenge that evidence on a summary judgment test or here on appeal, but even if accepted, I say that's insufficient to meet the test for a residential occupier. So before I develop those 2 points, on the law, there is a relatively long authorities bundle, but it is common ground that no one has been able to find a case where the Court of Appeal has looked at Section 106 before, and or payless notices. S&T and Grove, the Court of Appeal did look at payless notices, but only on the issue of whether there could be incorporation by reference, which is not, although arguably relevant, not the issue here. So where we're left with is, other than the House of Lords Court of Appeal authorities my learned friend now relies on the Landlord and Tenant Act, which I say are effectively irrelevant, a different act, a different test. you are unconstrained by authority. So although I will be taking you to some of the authorities, I say that principally this should be decided on the terms of the statute and first principles. So for that reason, I'll start with the Act. And obviously on this ground, we're concerned with Section 106. But before I get to Section 106, just to set it in context, and I know the court will be familiar with this, but it obviously feeds into the approach to be taken. So in the authorities bundle behind tab 1, page 3, Section 104 sets out construction contracts, and Part 2 of the Act, which is the payment and adjudication provisions, applies to construction contracts. And there is, of course, no dispute that this would be a construction contract. Section 105 sets out construction operations, with 105.1 being what are construction operations, 105.2 being what is excluded for certain industries. We then turn to Section 106 on page 6. And subsection 1, and there's just 2 points to draw out. Firstly, as the annotations show, Part B was repealed by the 2011 amendments because there was a new Section 106A at the bottom. So Part B is in fact no longer applicable to contracts after 2011. But obviously that's not relevant for us today. We're concerned with Part A. And the starting point is that Part A is an exception. Therefore, in my submission, it is to be approached narrowly. The intent for Parliament was that these rights to apply to all construction contracts, save those for which specific, and I would say limited, exceptions were provided. To then look at A in more detail, it refers to a residential occupier, and then there is in brackets C below, which takes us to 2. But I do say that in applying the definition in 2, it's important not to lose sight of the ultimate question being, were they residential occupiers? Those words have to be considered as well. So the definition in 2, there are several different elements. So firstly means a construction contract. As I say, there's no dispute there. There's then which principally, and although there are arguments on principally down below, I don't pursue any arguments on principally here, then relates to operations on a dwelling. Now this was a very substantial property, 12,000 square feet, pool, cinema, but I don't dispute it would be a dwelling, subject to my 2 arguments as to the terms of the development loan and the Airbnb. But then probably the crux of the appeal on this ground is the next 2 elements. Firstly, which one of the parties to the contract occupies or intends to occupy. And pausing there is no dispute that Mr. and Mrs. James, as a new build property, did not occupy at the time of the contract, have never occupied, and it's for sale. So
Can I just ask on a factual point about that?
Yes.
I understand that. I think the property was called Ferndown.
Yes.
Was that demolished before this contract or as part of this contract? I don't think it matters, it's just the chronology. Because obviously the property wasn't occupied because there wasn't a property on the site, it was being built. But I just, from a setting out the facts point, when was the original house knocked down? Part of this work or before?
My instructions are as before, but I'm conscious my learned friend may have a better grasp of it as well.
That would look to fit, because I don't see any reference to demolition.
No.
So that would fit. Okay, well, I'll work on that basis, Mr. Frampton, and then if Mr. Hannah has a better view, he can.
Yes, and I'll make a note, my lord, over lunch as well. I can see if there's something in the evidence.
Thank you.
Which helps.
Yeah. So if it was knocked down before this contract, there was nothing to occupy, so we're concerned with intent.
And I don't understand my learned friend to seek to suggest that he can fall. There was a prior property, or that even if there was, that they can meet the test by having occupied that different property. I think it's common ground that effectively they must fall under the intends to occupy limb of that part of the test. The third element then is his residence. Now, allowing for gender bias, the 2 points to pick up there is a possessive element, and secondly, it's referring to residence. That is a place you live, you reside. Now, as I said in opening, there is no court of appeal authority on this point, but it is perhaps helpful just to pick up what generally is regarded as the leading judgment on the test, my Lord's own judgment in Westfields, just to look at some of the points which were picked out there. But I of course accept that you're not in any way bound by those comments, and it is of course a case of its own different facts. But the case of Westfields can be found behind tab 5 of the authorities bundle, page 24. Now, it's right to observe that this was also an application for summary judgment, although there was perhaps unusually cross-examination.
I mean, if it helps, my recollection is the parties wanted a determination of the issue, and so there were directions allowing statements and allowing cross-examination.
Yes.
But obviously under the umbrella of summary judgment. But that is my recollection, and it's 13 years ago, so it may not be sound, but that's my recollection of what happened.
The points I just draw out from the judgment, starting on page 26. Paragraph 3, next to C, the sentence starting 6 lines down, ordinarily. The short point, which is obviously from the Act as well, that this is an exception and therefore the burden falls on the defendant, or here, the respondent. Page 27.
I don't think that's an issue.
No. Page 27, again, I don't think it's an issue. B, that the intention is to be at the time of formation of the contract. I don't seek to go behind that today, because of course it is now up for sale. It's still up for sale today. Paragraph 10, the explanation that Section 106 was intended to protect ordinary householders, not otherwise concerned with property or construction work, and without the resources of even relatively small contractors, from what was a new and untried system. And of course, I rely on that as a helpful explanation of part of the policy and the intent which must be considered, because part of the question must be, would Parliament have intended that employers under this sort of contract needed protection, needed to be excluded? And I say, for the reasons I'll come on to, clearly not. the final brief point to draw out is at the top of page 28. The concluding words by B at the end of paragraph 11, the top of 28, that it ought to be approached with common sense. It ought to be plain on a brief consideration of the facts, whether the employer is or is not a residential occupier within the terms of the exception. And I say that that is A, correct, but B, also shows that what is intended is an objective test. Now, that is not in dispute, but in my submission, one of the ways the judge fell into error, which I'll come on to, was he allowed subjective evidence, later evidence as to intent, to creep into what he referred to as the objective test. And I'll make
this paragraph is talking about the first of the two alternatives, which is whether somebody is an occupier, where one can see that that could well be and should well be an objective test, but we're concerned with intends to occupy, which inherently has at least a subjective element, doesn't it?
Well, my lord, I'm conscious I'm not the best person to speak to the intent of this paragraph, but as I read it, it's covering both.
Now, I was looking at the paragraph objectively.
Yeah. In my submission, the approach should be to be an objective. I don't think it's an objective assessment. The question as to whether you get into the subjective intent, I think that the dividing line or the problem, as I see it, is that the focus should be on what was expressed outwardly by parties at the time. What are the facts which are there? It is once you start.
Sorry to interrupt.
Sorry.
I'm sorry. Do finish.
The problem in my submission with the judge's reasoning was he allowed witness evidence put before him several years later of matters which wouldn't have been expressed at the time to influence his assessment of the subjective test.
Surely, if you're trying to discern what someone intended to do at a particular date,
Yes.
here the date of the contract, there has to be, as my lordship indicates, a subjective element to that. And in a judge deciding what that amounts to, he's got to be allowed to take into account the surrounding circumstances in order to inform that subjective element. There's obviously an objective element as well.
Yes.
You know, was it reasonably likely it could happen? Was it realistic and all that sort of thing? But surely at the beginning there's got to be a subjective element.
Well, in my submission, the weight and the weight to be given to that subjective element, if it is to be taken into account, perhaps maybe the key. And the question must be: once you look at the objective facts such as there, can the subjective evidence you have, can it coexist with it, or is it in fact contrary to it? Because that's what I'll come on to. That I'll say that the evidence you have effectively can't coexist with, can't fit with the objective evidence for development loan, and that's the problem here. The two. It's not like you have. It's not as if there's a piece of a jigsaw where you can fit them together and it makes it. Effectively, you have one side which just can't. The two can't coexist. They can't work together, and that's the problem. And that's where then you should the primacy should go to the objective element, particularly, and perhaps not just always in generalities, but particularly what the specific objective evidence I rely on here, which is particularly the fact, the nature, and the terms of the development loan.
Thank you.
As I say, for the reasons I would give, I don't. That is as much as I intend to take of the law on this point, because really I think it is for the court to consider Section 106 in the wider context of the Act, in its policy context, and decide how it applies, what the words mean, and how it applies in this case. So the key then is the facts, and as I've outlined, I'm not, of course, inviting the court to make a determination on all the disputed facts which were before it. And what I say is there are two grounds on which those facts can be determined to be irrelevant. Now, before I go on to develop those two grounds, there are four other key points just to draw out, part of the broader context. Firstly, as I've already said, Mr. and Mrs. James never occupied the property at the time of the contract or subsequently. Secondly...
Well, if it was demolished, they couldn't.
The prior...
At the time of the contract.
Yes.
If the house had been demolished, they couldn't occupy it.
No, exactly, my lord. They now intend to sell the property. It was first marketed for sale in October 2023. The contract was January 22. So it's an oral contract.
Is it your case that the terms of the loan necessarily trump whatever the facts are? So suppose Mr. and Mrs. James had written to all of their contacts saying, once this work is completed, we're going to be living here. We hope you'll come and see us. All the rest of it, they do other things. Where they join all the local clubs. They have their caravan in the grounds and so forth. Whatever they do, the loan wins. As a matter of law, effectively.
Yes, I mean, my lord, that's obviously not the facts here, but I accept that probably is where my argument goes.
That's the implication of your case.
Yes, exactly, my lord. And
so the judge shouldn't have looked at anything else. The judge should have looked at the terms of the loan and said, that is the answer. And that's why I say it was wrong to say it needs to go for trial, because the development loan is the answer. I think that probably it's right to turn to the development loan. That really is the crux of my case. The first loan is in the supplemental bundle behind tab 10A at page 152. And this loan, starting on page 152, just to pick up, and 153, pick up four preliminary points. Firstly, it's dated 10th November 2021, so it's there at the time of the contract in January 22. Secondly, the borrowers in the second recital are Tracy and James, the second respondent. The first respondent is not a party to the loan, is not actually an owner of the property, and CASEC Limited. Now, CASEC Limited is a property development company of which Mr. James is a director, as what was recorded by the judge in the judgment. And Mr. James therefore does sign this loan on behalf of CASEC Limited at page 190. Now, just to pick through the points I draw out from this loan and then get to the key issues really, which are then the undertakings, but the points I do draw out. Firstly, you can see that on page 153 there's an arrangement fee of £103,000. Page 154, the charged property, you can see that it's partly charged over the development we're concerned with, which is Ferndown, and that's also referred to as the development property in the definitions on 154. Page 156, just to pick up two definitions. The interest rate is 2.25% per calendar month, and the loan, you can see the amount is up to, at this stage, 3.7 million. The expiry date is 30th of April 2023. Now, effectively, further loans have been taken out, extending both the date and the sum. As far as we know, up to April 25. We've asked, but we've not been told what's happened since.
So originally it was up to April 2023.
Yes.
But you're aware it's been extended to April 2025.
Yes. By coincidence, the last extension we received was to the 30th of April 25, which was in fact the very day of the hearing before the judge last year.
Yeah.
And we haven't put that loan in the bundle just because it's exactly the same, other than those points changing. You do have the undertakings which went with that loan, which are again in the same terms in the bundle. But I don't think that's disputed.
Yeah.
And then the final point to pick on 156, there is a monitoring surveyor acting for the lender. Then moving to the operative terms of the loan, page 158, there are a number of preconditions. That is, preconditions to the lender being under obligation to release all or any part of the loan. And to do so, the conditions have to be satisfied. Now, the particular conditions I rely upon or draw out are 213, 214, page 159. 213 is the lender has received and is satisfied with a written undertaking signed by the borrower that the charged property is not used as and will not be used as a dwelling. And of course I do emphasise the word dwelling because that is the word in the Act. And we'll come on to those undertakings in a minute. The second condition I particularly rely on is 214. The lender has received and is satisfied with written undertaking signed by the borrower that the loan will be used for business purposes. Of course, I say that's inconsistent with saying you're a residential occupier. Residential distinct from commercial. Now, before we get to the undertakings, just a few more points to draw out from the loan. Page 166. It contains the representations and warranties. B is a representation and warranty that the loan agreement and all the other documents are valid, legal and binding obligations. D, there's a representation as to the correctness of information which has been supplied. And 10.2 over the page 168, there's those warranties, reputations need to be repeated at each drawdown date. So then turn to the terms of the declarations themselves. Page 189, we can see the signature pages, and 192, we have the first. In fact, if we can go to the signed version, the first declaration is at 195. So there are three different undertakings which were required. The one on page 195 is the undertaking referred to in clause 213.
Hang on. So there are three undertakings.
Yes.
First is page 195, and that relates to clause
213.
213, yeah.
Yes,
Second,
which is the dwelling. And then there's one at 196 and 197, which both relate to 214, the business purpose undertakings.
Yeah.
So 195 is what I'll call the dwelling undertaking, 196, 197, the business purpose undertaking.
Yeah.
So the first undertaking, it's now it's important just to pick out the heading. It says confirmation regarding occupation and use of property, and refers to Article 60D of the Financial Services and Markets Act 2000, Regulated Activities Order 2001. Now that article forms part of Chapter 14 A of the order, which regulates credit agreements. And one of the exemptions where credit agreements don't need to be regulated is under Article 60, which is if a credit agreement is for sums which are secured by a legal mortgage on land which is not used or intended to be used as a dwelling by the borrower or a related person. So these undertakings are key because without them they would have to be regulated loans. The idea is this is an unregulated loan. So the undertakings are the basis on which this loan can be given. And to look then at the detail of the declaration which is made, the key element is the last 3 lines. We declare, confirm and certify that neither myself, ourselves, nor any of our family or close relatives, nor or our partner reside or have any intention to reside at the property. And I do flag, because the respondents say, well, we understood that was only for the time of development loan. But there is no such temporal limit here. That is an absolute confirmation that they do not have any intention to reside at the property or any intention to occupy the property as their residence.
What interest does the lender have in what happens at the property after the loan has been repaid?
They may not have an interest in the property, my lord, but of course if they've given loans on an unregulated basis, which is a certain way, relying on certain undertakings, they would have, I think, an interest if they thought that not an interest in the property, but they would have an interest more generally if they thought that in fact those loans would be given on an incorrect basis, and therefore they should have had to be regulated, or should have gone through that way. They're obviously
why would they care? The loan is given.
Yes.
There's no residing at the property. The development work is completed and the loan is paid back. Well, why does the lender care or have any right to care what happens thereafter?
Well, my lord, I get my submission is less. I'm not. I guess in a sense, I'm not worried about I'm not less worried about the lender because obviously I'm not here for the lender. The relevance, of course, is I think it's sometimes it's said, well, this is a third-party agreement. What's the relevance? But of course, this is crucial because it's not an unrelated document. This is the loan which provide the money to carry out the property, i.e., to enter into the contract with and to pay my client. My client is paid under the basis of this agreement.
Well, I follow that, but your case depends upon this and other clauses like it in the loan document.
Yes.
And I asked why should the lender care, because that may have a bearing on what this promise actually means.
Well, my lord, my submission, this is a signed written undertaking on the basis of which the loan is given, and the loan could not be given on the basis on which it was without it. And the evidence, Mr. and Mrs. James's own evidence, is this was the only loan available, the only people willing to loan. So I would say that I guess to go back to my point, it's less does the lender declare, it's more that in my submission the property wouldn't have been built without these undertakings. You wouldn't have had the contract, you wouldn't have had the contract with my client. And that's where I say that's how the relevance and the link comes in.
So you say this has to be interpreted as if at the end of this undertaking we were to add the words until the crack of doom.
Well, the judge accepted there was no temporal limit on this, and on my submission that's right. I don't think you need to add the words. I say the natural and ordinary meaning, if you don't have any intention to reside, is there is
Just give us the paragraph where the judge said that.
Yes. Paragraph, page 71.
Yeah, I'm on page 71.
Yes. Paragraph 42.
Yeah.
So he.
Where does he say that this contract had no end?
So he said, starting in this respect, he said, I note that Mr. and Mrs. James both say their understanding of the loan declaration was they were declaring they would not live in the property for the duration of the loan.
Mm-hmm.
So Mr. Frampton fairly points out that this is not what the declarations say.
Yes.
So,
well, that's not a finding by the judge that this was not temporary. That's a submission.
well, I mean, obviously, I accept that the judge. I accept that, my lady. The other point, of course, in terms of temporal, is if you then move to the second and third declaration, to page 196, 197, which is the next point the judge made in that same paragraph. 196, 197, these say, and again, these are declarations needed to secure the exemption from being regulated. I am entering this agreement wholly or predominantly for the purposes of for a business carried on by me or intended to be carried on by me. Now, there can't be any temporal limit to that. It can't be said, well, I'm entering it for a business until I've paid it off and then I change. If you're assessing the intention at the date of the contract, it has to be it's for a business.
Well, is that right? So if someone building this house, say that
yes.
It was always a development project, are you saying that when this house was completed,
yes,
the couple, Mr. and Mrs. James, completely fell in love with it and said, "This is just lovely. Let's keep it. We love it." You're saying that they are prohibited from changing their mind and doing so as a result of these two undertakings?
No, my ladies, sorry, it's slightly different point, because Mr. and Mrs. James say, not we changed our mind later.
No, I was asking you the abstract question. You were saying this goes on forever. Whatever you say.
Well, is in when you make it, it has to be an intention you hold forever. Not to say you can't later change your mind, but that's changing your intention. But if you're assessing your intention at the time you make it, you can't say, oh, what we meant by that is we were entering it for a business purpose only for the duration of the contract. Mm-hmm. That just can't make sense.
Why?
We wouldn't give any effect to that we're entering it for a business purpose if you're saying, well, it's only a business purpose while we need the loan. It can't be right that as soon as you've paid off the loan, you say, well, it is now no longer for a business purpose. That would, in my submission, be.
Why not? It means you don't get the protection of the Financial Services Markets Act because you've contracted out of that. But that's a different question, and that's what the lender is worried about. But if you do change your mind, why shouldn't you?
Well, my lord, it's as I say, the point is less you can't change your mind later. It's more you can't. The court should not accept a submission now that the case being advanced by the respondent is not inconsistent with these declarations, because these declarations were, when they were given, were always time limited. I say that's not what the language of either of them is, but also particularly on the business use, I say that any interpretation which adds the words only for the duration of this loan does not work. The purpose cannot switch in that way. When you're building the property, either you're building it for a business purpose or you're not. You can't say, well, we're adopting a fiction that this is for a business purpose, just for the duration of this 3-year loan while you give us the money. But in reality, as soon as we paid you off, it's no longer a business purpose.
You do not accept, as the judge put it at paragraph 44, that the matters you've taken to us require an explanation, very clearly raise the possibility that the house was being constructed as a development for onward sale, but that's part of the picture which has to be set against the James's evidence. You say the judge should have just ignored everything else.
Yes, my lady, I say that it's not part of the picture. It should have been the whole picture in terms of the judge's determination of the issue. And the reason I say that, factually, as I say, the reason... Now, before I move on, sorry, there are other loans as well which were obtained, secondary loans, which had similar undertakings not to intentional reside. But I understand my point doesn't get better by repetition.
Well, thank you. Yeah, well,
yes, I don't propose to take you through all of them.
No,
just for your notes, if you wanted the further undertakings for the latest known at page 313 of the bundle. But again, this is not, you can just see the value's gone up to 4.4 million. But again, I accept repetition doesn't assist me. Effectively, I have to make it good on the one loan or I don't make it good. So the facts, why I say this development loan is the complete answer. Firstly, just to stand back and consider the facts. As I say, these are the very agreements by which Mr. and Mrs. James were able to get the money to enter the contract with my client and pay for the works. Secondly, when you look at this, before you look at the detailed terms, it is obvious that this is not a residential occupier type loan. This is not your standard mortgage. This is not a self-built mortgage. This is a commercial development loan with monitoring surveyors, very high levels of interest rate, very high fees. And thirdly, and of course really the key, is then you have the signed undertakings, which in my submission should be read as saying they had no intention, if necessary, ever, of residing in the property, and it was for a business purpose. And absent those undertakings, Mr. and Mrs. James wouldn't have received the loan. They wouldn't have entered into a contract with my client. They wouldn't have been able to pay for the works. So how can it be right that they can now come to court and say, well, actually, we did intend to reside. Ignore what we said there. We're a residential occupier. Just to pick up my learned friend's...
Sorry, well, that sounds if it's a kind of estoppel or something.
I don't put it in that way, my lord. I put it in the way that it's when you look at the objective... Right, there's various ways I can put.
You're saying how can they say something?
Yes.
Which might be true, but they're not allowed to say it because they've signed this loan.
Well, it could. The court could take it in that way. I mean, my submission would be where you've given signed undertakings and then you're applying your objective test. You say, okay, well, the objective test. You start with those signed undertakings, and the point is their evidence can't coexist with or change those undertakings. The only way their subjective evidence could work would be to ignore those undertakings. And I say that's where the judge went wrong when saying it was part of the picture, because that only makes sense if you say, well, you could ignore those undertakings in due course.
These are obviously not undertakings given to you.
No, I accept that.
Do you get to see the development loan?
It was only disclosed to us during the proceedings.
Yes.
We didn't have it at the time. So no, I can't.
So if it were an estoppel, it simply wouldn't work.
Yeah, this is why I don't put it on that basis, my lord. So just to pick up then my learned friend's response to this point. Page...
Are we turning to his skeleton argument?
Yes, in his skeleton argument, yes, exactly. Page 50, just tab 3.
Would you mind giving me the paragraph number?
Yes, paragraph 37.3.
Thank you.
and my learned friend summarises the evidence given by his client. The second sentence said that the development loans were taken out because conventional consumer mortgages are not available for construction of a new home. But there are consumer self-built mortgages, and this is not what we have. We have a commercial development loan.
Well, wouldn't that be part of the evidence for if there was to be a trial?
Well, I don't think it's.
How can you assert that they are out there if there's no evidence about that? Or was there evidence about that?
I'm not aware of any specific evidence. I would make it as a base. I make it on submission as generally such self-built mortgages are available. But I accept I can't put any higher than that. The next paragraph, the next sentence says there was an intention to repay once they were complete. It says they're expressed as short term. The third sentence, which is the point we talked about, and we looked at in the judgment, it said his evidence is that when signing the development loan declarations, his understanding was this meant they could not live in the house until the loan was paid off. Now, just to pick up that evidence then, page 13 of the supplemental bundle. So this was Mr. James's first witness statement. Page 13, paragraph 2.1. He said, in the middle of that paragraph, as confirmed at paragraph 6 below, as part of the development loan, we had to sign a declaration we would not reside in the property for the term of development loan. And that's repeated at 6.2 in the same terms, page 15. Now, I do make 3 points. One, I say that's not, and at this stage, we weren't provided with the development loan. Mr. James didn't actually sign the undertakings, it was Mrs. James. And of course, we've looked at them. No matter how they may be understood, the terms did not say we will not reside in them for the duration of the development loan. They said we have no intention of residing. And the third point is there is no reference here to the business purpose undertakings. It's not addressed. Page 122, just to complete the picture of how the evidence emerged. Mrs. James's first witness statement, page 122, tab 5 of the supplemental bundle. Despite being the party who signed the undertakings, in her first statement she did not in fact address the undertakings at all.
Well, hers wasn't it? Sorry, I glanced through this last week. Wasn't this effectively just confirming what was said in her husband's? Wasn't it a very short? Didn't go into detail, did it?
No, yes, exactly. It repeated the statements made by Mr. James then.
Is it right for us to draw adverse inferences for the fact that she didn't deal with all the things that her husband had dealt with in his statement?
Well, I'm not going as far as to invite adverse inferences. I'm just going through the story of how the evidence emerged.
The judge has dealt with this.
Yes.
I mean, we understand your point of principle.
Yes.
But I think it unlikely we'll be trawling through I think it's 7 statements, maybe 8, in any great detail. So so the story of how the evidence emerged, what's the point that is made as a result of the story as to how the evidence emerged?
My lord, the short. I'm grateful for that undertaking. I can take it more briefly. The point I would draw from it is it shows that there is no good answer to the undertakings, particularly to the business use undertaking, and that it shows that despite everything, there is no way to reconcile their case with those 2 undertakings. The first undertaking relies on saying, well, that was only for the time of the loan. I say that's wrong. But certainly when you get to the business use, there is no answer. My lord, I'm grateful for your indication. There's just one other...
So no answer to the business
use.
case.
Yes.
That's the ultimate point.
Yes, my lord.
You wanted to take us to one other document.
Yes, just one other element of just to pick out the two important points of the evidence. In Mr. James's second witness statement, page 145,
Yes.
paragraph 2.3, Mr. James refers to asking a friend who's a broker to find a loan, and just to identify that 5 lines down, Mr. Dempsey advised us that given the size of the loan, the only lender he'd been able to identify as willing to lend money for the size of this project was MSP. So it was the only loan available. Then paragraph 212, 146, Mr. James accepted that the significance of the declarations is to lend and borrow money in a way which is not regulated. So just to make those 2 points which I addressed earlier, and I say that that's not disputing the evidence. So standing back then, and ultimately I accept that my case comes down to the terms of the development loan on this point, and particularly the undertakings. In my submission, it cannot or should not be accepted that Mr. and Mrs. James are, and the ultimate test is residential occupiers. That's the ultimate requirement. They do not meet either word. Residential is distinct from commercial business. They gave undertakings for which they got the money, but this was for a business purpose. It's not residential. They are not occupiers, and here they have to rely on the intent to occupy, because again they gave undertakings. They had no intention of occupying. So just in terms of to develop just to set out the legal basis then on which I then make good that point. Firstly and most simply, I say that when you're looking at this objective test, the development loan, particularly the undertakings, is the complete answer.
You say it's the slam dunk.
Yes, exactly. And I say that the evidence of subjective intent doesn't necessitate a trial to weigh it in the balance, because it's not compatible with the objective test. The court should not be saying, well, maybe these undertakings were wrong or were false, and assessing that at trial. Instead, the approach should be, we'll accept those undertakings, and that is the basis on which we determine the subjective test. And
so you say that, do you? Even if Mr. and Mrs. James' intention actual intention was as they say, and they genuinely, you would say, misunderstood the terms of the loan. They thought they were giving more limited undertakings than you say they actually were. But even then, they're stuck as a matter of law with the undertakings they gave.
Well, I would say on an objective test, you must be interpreting the written terms of the undertakings they gave. So yes. And just to buttress that, if you consider the point we started with, that this is meant to be a narrow exception, the policy intent for it is to protect ordinary homeowners. These sorts of commercial development loan arrangements, parties with those sorts of arrangements, not who Parliament intended to have protection, not the scope, the narrow scope of people they were intending to protect. It does not fall within a residential occupier.
So is that it on ground one?
Well, I do put it on a slightly, in terms of legal reasoning, I do have a slightly secondary basis, which is that the occupation would be, although it obviously rather runs together, the occupation would be unlawful or contrary to those undertakings. That's where I rely on the case of Howsons and Redfern, where, very briefly, that was a contract for the conversion of a derelict agricultural barn.
And they only got planning permission because it was a live-work unit. They wouldn't have got planning permission for it otherwise.
Exactly.
So it wasn't regarded as, they weren't regarded as residential occupiers.
Yes, ma'am.
Yeah.
Now, to be clear, I think my learned friend suggests the evidence on that case was they wouldn't have been able to obtain permission to reside. But of course, they were residing, they were living in it. It's just under a permission for a live-work unit. Now, very briefly, the judge did address this point, just to deal head-on with his reasoning. Paragraph 41, page 70.
Sorry, you've got me there. Howsons.
Is, sorry, in the main bundle, just dealing with the judge's reasoning, my lord. I can take you through the authority in more detail, but I thought
the judgment. The judges.
Sorry, the judge in this case, my lord. I apologise. Yeah. Yes. I'm happy to take the court through Howsons in more detail, but page 70 of the page 70 behind tab 6 in the core bundle, my lord.
Yeah.
And so the judge dealt with Howsons there. He said, and his point was that a loan agreement with a third-party financier is different in kind to a statutory regulation. Breach of planning conditions is unlawful and may be subject to a penalty. Breach of a loan agreement is a civil matter and may sound damages for breach of contract. Now, I accept, of course, that I don't have a planning permission here, but in my submission there is the principle in Howsons, which was in my submission that unlawful occupation shouldn't be permitted and/or you shouldn't be able to come to court to assert something different to what you said to get planning permission, should also apply here.
I appreciate that's what Howsons says.
Yes.
But as you said, we're not bound by it.
No.
Why should an intention to do something which is unlawful not still be an intention? After all, the criminal law is full of that. You intend to kill somebody. That's murder. But you can't say, oh, well, it wasn't my intention because it was unlawful.
Well, my lord, in my submission, when looking at this test objectively, and I understand Howsons to be more on the former basis of saying, well, once you look at the planning permission, how you interpret it, effectively we're going to accept that, and we're not going to allow you to say something different. And that I say is the former basis. And in terms of the secondary, not permit something illegal, in my submission that should just follow as a matter of interpretation of the Act, that Parliament wouldn't have intended unlawful occupation to be permitted, so to be sufficient. Thank you. I don't propose to go through Howsons in more detail. I appreciate
Do you accept that there is a difference between a planning condition and an agreement with a third party? I mean, you use the word unlawful.
Yes.
But that's because, on your case, they would have been or were in breach of the terms of the development loan.
Yes.
But that's an agreement with a third party. I mean, there are hundreds of thousands of people around the country who are behind with their mortgage payments. So they're in breach of their agreements with their mortgagees. But they might be a bit taken aback to be told their occupation of their properties was unlawful. I mean, this is quite a significant difference in kind, isn't there?
I accept that, my lord, but I do. Of course, there is a difference, I would say, here, where you're looking at the intention test, because that would be. There's a difference between saying you ultimately end up in breach of an agreement, as opposed to saying, well, your intention would be in breach of the agreement. As I say, I raise it as a second legal basis, but I can see that ultimately all roads, they all lead back to the same starting point, which is the development loan and the undertaking.
If it's sufficient to be unlawful that it's a breach of contract, would one then not have to look to see what the view of the other party to the contract was? They might be quite happy. They might waive the breach, or they might say, well, never mind, don't worry about that. What then?
Well, my lord, I think on the facts here, the evidence is to be provided. Say the bank had known, and when they kept giving further loans, they wouldn't have been able to, because to be unregulated, to give this loan, they had to have those undertakings would have to be satisfied they were correct. So say that on the factual situation you have here, it is not a case where you can say that the breach may have been acceptable. They wouldn't have been able to give this loan.
Does the fact that they were sending someone round to have a look and monitor it, who was satisfied that terms were being complied with, factor in, fit in, relevant?
In my submission, no. Given the regulations accepted by Mr. James in his evidence, given that the bank couldn't give, and they kept asking for further declarations and kept receiving them, it's not as if they can say, "Oh, we now have understood your position's changed."
No, but they went along and they saw the caravan and so on and
yes.
so forth.
Well, in my submission, that's not inconsistent with the undertakings they were given. The fact they were living in a caravan on site doesn't mean it's not for a business purpose and they have no intention of residing. So that's the first ground on which I say the judge was wrong on jurisdiction. The second ground is on which I can take more briefly because it's a shorter point.
Payless notice.
Oh, sorry, no, it's just on jurisdiction.
Oh, sorry,
is payless notice paid? Will be short.
Airbnb.
Airbnb.
Sorry,
yes, my lord. Just to pick up then the evidence, supplemental bundle, page 18.
Well, it's set out in the judgment, isn't it?
Yes.
Unless you say the judge
No, my lord. I think the judge had the facts before him correctly. So yes, we can take it in the judgment.
So it is paragraph 34 of the judgment, page 69.
Yes. Yes, my lord. So exactly. Now, so the judge didn't accept this argument for two reasons. Firstly, he said it was a misapplication of the word principally, and I don't press reliance on principally. I accept the judge's point there. But however, his view was that a property you rent out 25% of the time under a holiday buy-to-let mortgage could still be your residence. And the short point I say is that was incorrect.
So if someone is fortunate enough
yes.
to be able to go and spend the winter in Portugal, Spain, fantasise about where it might be,
yes.
That means that they regard as their principal private residence, for example, CGT purposes, is no longer their residence.
Well, my lady, I focused under this act and this provision and this test, And I'd say the
You have different definitions of residence depending on the Act.
well, it is often the case that when looking at different statutory provisions within the full nature of that Act, terms of that Act, and the context, that different approaches to particular words will be used. Yes. Obviously, so the starting point here is that you're ultimately looking at, are they residential occupiers?
Mm-hmm.
Do they intend to occupy as
Yeah.
their residence? And there's two elements to it. One is not just the Airbnb, but the fact that it's not just they want to rent it; it's the fact that they have to rent it to pay for the.
Someone might have to rent out their house in order to rent a place in Spain, Portugal, or wherever for the winter.
Yeah. Well, in my submission,
Would that stop that being their residence?
Well, I mean, as I say, it's a short point. On my submission, that sort of arrangement would fall outside of the narrow exception, which is in section 106.
Where do you draw the line? What if it was 20% of the time or 10% of the time?
I don't think it's a point where it would be right to draw a hard and fast or black and white line. In my submission, the evidence you have here that needing to rent it out 25% of the time under a holiday buy-to-let mortgage, which are types of mortgage which prohibit you from occupying for the whole year. Not only you can, but you're not allowed to live in it 52 weeks a year. I'd say that sort of arrangement on the facts we have here is the wrong side of the line, my lord.
Well, I appreciate you say it's the wrong side of the line. I just wondered if there was a line, and if so,
Well,
where
it would be a matter of assessment for the court in each case.
So you accept then, although you decline to tell us where the line is, you accept that there would be one somewhere, so that letting it out for...
Yeah, so I mean, if you let it out for one weekend a year, I could see the court may have a different assessment as to where that falls. But a stated intention, the key point obviously again, this is not ad hoc or voluntary. It is a planned intention from the very start that they will have to do it to pay for the mortgage. Unless there's anything else further, that deals with my submissions on jurisdiction.
Your skeleton raises a question of estoppel.
Yes, my lord.
Is that pursued?
It's not, my lord. I accept I didn't run it before, down below, and I accept there are limits on the points, and also I recognise it's a summary judgment. No, my lord. Thank you, my lord. Sorry, I meant to flag. I don't
No, that's fine.
Thank you for being so practical and sensible.
Yeah.
So that's jurisdiction.
Yes.
Thank you very much. That's very helpful. Now we really are going to move on to the payless.
Yes, we are finally at the payless notice.
Right.
My lady's enthusiasm is unbounded.
Oh, well, having become a recent convert to payless notices, I feel
it's a very exciting
get the full
world.
benefit of it.
Yes, exactly.
Although I have to say, I have learnt at my master's feet in other cases about payless notices.
Yes. Well, the book is where most of us start and we learn. So
I haven't gone that far.
I think it's a very good book, although maybe you need an update. Yes. So to start again with the Act, because as I've said in opening, although I don't think necessarily there is much between my learned friend and I in terms of the overall law, again, it's the application to these facts, as on both grounds ultimately.
So we're back to the authorities bundle.
We're back to the authorities bundle. We're back to the familiar territory of the Housing Grants Act. In page, we'll picking it up from page 11.
Okay.
Before we look at the terms of the Act, I appreciate I'm telling this court how to suck eggs, but of course it's right to observe that these provisions, the reason these provisions came in and then were amended in 2011, is to go back to the Latham report and the 1990s in a policy and a process where main contractors' employers were not paying subcontractors, were then coming up with grounds, often spurious and not clearly set out, as to why they wouldn't pay, and thereby defeating summary judgment applications when the contractor said, well, look, here's our invoice, pay up, and suddenly they're faced with all sorts of claims they hadn't known about before or couldn't deal with. Now, I say that's important because these provisions are all really focusing on what you may call a cards on the table approach, that Parliament intended to say, well, you have to pay, and if you're not going to pay, you need to say what you are going to pay and why. And that is the policy intent behind these provisions and from which the court should start. So then to look at the process, and I say ultimately that the document you have here is effectively going back to what the Act was intended to prevent. So to look at the process in the Act, now obviously the first stage of the payment process is not in fact in the Act, strictly it's the application. So there's no challenge to the validity of the application here, we have the application. The Act would then allow...
We need to look at the application because of course it's part of
the context. Exactly, my lord, yes.
And I've got some questions, so we'll come to that in
yes, I plan to come
to your...
Yes, my lord.
However you deal with it, yeah.
I'm grateful, my lord. But absolutely, the application is a key part of the context. The 110A has provision for payment notices, and of course there's no argument that a payment notice was given. We then turn to section 111, where there's the requirement to pay the notified sum, or payless notice provision, page 13. And the notified sum is the sum set due by the payment notice, or if there is no payment notice, but the contract allowed applications and application. The key subsection we are concerned with is 3 and 4. 3 says the payer or a specified person may, in accordance with this section, give to the payee a notice of the payer's intention to pay less than the notified sum. So to avoid having to pay the notified sum, you can give a notice, a pay less notice. Subsection 4 then has the requirements which must be specified. I do emphasise that language. A, the sum that the payer considers to be due. And B, the basis on which that sum, i.e. the sum the payer considers to be due, is calculated. I do emphasise the word calculated. The then closing words confirm that even if the sum's 0, you still have to comply with this subsection. Now it's important to note in my submission that section 111 was an amendment in the 2011 Local Democracy Act. So the previous section 111 is page 19 of the Authorities Bundle, tab 2. And previously, we had a concept of withholding notice, or a notice of intention to withhold payment. And subsection 2, slightly different requirements. If A, the amount proposed to be withheld and the ground for withholding, or B, if there is more than one ground, each ground and the amount attributable to it. So there has been a change in the provisions, and I say that the intent which should be drawn from that change is less starting with what the other party has sought and saying no, not that, and actually more focusing on you need to do your calculation, you need to do your assessment, because that goes to the very policy intent of the Act, to make, rather than someone just say, oh well, let's just say nothing and throw something back. Actually, you should sit down and do your own calculation and assess what you consider to be the sum due, and then explain it to them. That is what the notice provisions are aimed at and require to stop the process we had in the 90s. Now, just briefly, to look at one case, because as obviously you're not bound by it, this is typically regarded as, although perhaps maybe until this judgment, what is currently regarded as the leading statement on principles of payless notices is the judgment by Joanna Smith. This is Justice Joanna Smith in Advance and Aniska, which is tab 12, page 133 of the bundle. It's judgment from 2022, which is still generally cited as the leading statement of the principles. And those principles, after a lengthy review of the authorities, are on page 150, paragraph 47. And I don't seek to disagree with any of these as a matter of principle. It's the application. And of course, this was a case on its different facts. But the points I do draw out are two. The notice is to be construed into taking account the relevant objective contextual scene. So it's all the context. Over the page, point 5. It's a repetition really of the statutory requirements we've looked at, but to qualify as a valid notice, any payment notice, and I should say that the same approach would apply to payless notices because the statutory requirement is the same. Payment and payless notice must clearly set out the sum which is due and must be deducted and the basis on which the sum is calculated. And the final point, which is a test which is often applied, or approach often applied, is 9. One way of testing the validity or otherwise of a payless notice would see whether it provides an adequate agenda for an adjudication as the true value of the works. So now to turn to look at the facts here, just before I do, to summarise my case, the 3 key reasons why I say this payless notice or purported payless notice is insufficient are threefold. Firstly, there is a mismatch between sum due and basis for how calculated.
So a mismatch between sum due
yes. and the basis for how, and the figure which would arrive at on the basis of how it's calculated.
And the figure?
If you were to take what's said to be the basis for how the sum is calculated, that would arrive at a different figure from the sum which is said to be due. And I will explain that in more detail as I go through my work. Secondly, the language is not consistent with a calculation or setting out the basis of a calculation of the sum due. And thirdly, I say ultimately, if there is an attempt to set out the basis on which the sum due is calculated, it's insufficient. And overall, this is exactly the sort of approach which the Act was designed to avoid. And I do, obviously, it's not binding, but I do observe that an adjudicator who would be perhaps the best person to know if it's an adequate agenda for adjudication, decided it was insufficient. So before we look at the documents then, and to make good those points in more detail, the context, because as we've looked at, part of, it's not just the notice in isolation, I accept that, it's the context. And there are 5 elements of the context which I rely on. Context 1, this is not a lump sum contract. There is a fee, the supervision and project management, and then effectively it's cost reimbursable.
Well, that second point, it became cost reimbursable. The contract originally was for the £1,000 a week, £10,000 a month.
Yes, my lord, I think that's right. Yes.
So
But by the time we get to the relevant application and pay less notice, it's not in dispute. But the contractual terms were for, or payment terms. Obviously, it's oral, but it was not in dispute that the terms were to be fee plus cost reimbursable. There is a factual dispute on.
Well, there are a number of factual disputes. Leave those aside. But it became cost reimbursable in addition to the fee for management.
Yes.
Yeah.
Secondly, this is a very substantial project, and I do say that is relevant when considering the context. My client had already been paid £1.3 million and was making an application of 600,000. Thirdly, context. The application for payment was in November 24, so after the works had stopped in April 2024. So it was a valuation taking into account all of the works. And sorry, I think I said
final account claim.
I think it was. In fact,
it didn't say
put
that.
as an interim application.
Well, it didn't say either. But one would have expected, given a wait of 8 months between the end of the works and this claim, one would have expected it to have been a final account claim. It didn't say that.
No.
But that's what one would have expected.
Yes, but the context I draw out is it wasn't an application or an assessment made with an expectation that things would be developing the next month or afterwards. It's understood that the works, I don't think the property was actually finished, but there'd been a dispute and the works were stopped. They'd stopped and there was no more works to be done by my client. Or no more works were going to be done by my client.
So it was a final account.
In terms of how it was and obviously the validity of the application is not before you. There's no challenge by way of parte to the adjudicator's decision. I think it was put as a interim payment application in the adjudications. I'll check over lunch.
We'll look at it. We're going to look at it.
Yes.
But I'm just getting the context.
Yes. I just don't want to mislead the court in saying, yes, definitely this was a formally put as a final payment application.
No, it didn't say that.
Yeah. No. But in terms of kind of practical, yes, you could consider it a final account. Yes. Exactly.
Thank you.
Yeah.
The final context is a point my lord has already referred to, is the application. And it perhaps is helpful to pick up the application first before we move on to the pay less notice. So that's Supplemental Bundle tab 4, page 61.
Yeah.
And we have a covering email setting out the payment application, and then what we have is a very detailed. It was in Excel, and it's been PDF'd and printed. I think happily and unusually, perhaps in a way which is still legible. We could just to pick through.
So, first point, you say this is a payment notice under Section 110.
Yes, my lord. With Section 110B.
Yeah.
Yes.
Yep.
Yes, my lord.
Okay. There's no evidence that there were any prior discussions about this claim. I've looked, I hope, fairly carefully. I can't see any discussions, any reference to discussions at all. So it was an application made some months after the works had come to an end.
Yes, my lord.
Okay. And were there 2 spreadsheets?
No, my lord. It was one spreadsheet with 3 different sheets. I think 3 or 4 different sheets. We can provide a soft copy if that.
Well,
assists.
There's page 1 of 10, which starts at
yes,
page
so
62.
That's one sheet of the document. I think. Yes, so that effectively there are 3 sheets, my lord. We have the first sheet has the heading of RBH application for payment, and that's what we see at pages 1 to 10. Then at page 72, that is then a different sheet, which is an invoice schedule. I think that sheet is headed RBH, and then.
So what's the difference between the two? Since in the main, but not entirely, they are each referring to invoices.
Yes, my lord, the only difference is one of them lists all of the invoices. So the invoices are the same, it's just in the prior document they've been grouped by categories of cost. So you can see on page 83, the total invoiced figure is 1.62 million plus 119,000 of VAT, and we can see that is the same figure we have on page 71.
Yes, I understand that.
Yes. So all that's happened, my lord.
So it's the same invoices.
Yes.
Are just being regrouped.
They've just been grouped together by categories of cost in the first sheet, my lord. So, for example, if we look on page 62, the first category is called Roger Huntley Supervision. So those are all those costs. We then have.
I see. So line item 10 is actually a heading.
Yes.
Yeah.
Exactly, my
So
lord.
looking at page 5, we've got groundworks and then all the.
Yes, so we can then see that. Yeah. So page 4, in fact, is the second subheading, which is labour, skilled and unskilled labour.
Yeah.
And then the one at the bottom of page 4, page 65 of the bundle is subcontractors.
Yeah.
And then
Now,
there is
can I just ask this?
Yes.
There's a reference to, as I understand it, an invoice. I mean, if we take the top of page 4 of 10, 28/2/2023, that's in column B, and that's an invoice date is the head of the column.
Yes.
So one understands that the first invoices are the invoices that were due for supervision.
Yes.
But then we get to invoices for, as you say at the top of page, for labour and unskilled.
Yes, my lord.
What are those invoices? From whom to whom?
I'll have to take instructions, my lord, and come back to you on that.
I mean, it's completely unclear on the face of the document. One understands, as I say, that the invoices from RBH to Mr. and Mrs. James, the 10,000, the 1,000, would have been invoices directly to them. But it's completely unclear what the next items are and whether they are invoices sent. Well, it's not clear who they were sent from and to.
Yes.
And the same point then becomes true once you get to ground workers, Hanson, contract welding, and so on. And I don't think the grouping thing works because they interrelate.
My lord, I will come back to you.
It's just really this question. This isn't how you do a proper application, particularly for payment after some months off-site when one might assume it was a final account. I get the invoices for the supervision because that was different, but for the actual works, it's on the face of it, it's quite unclear.
Some of these look as if there is initially an invoice to RBH, and then RBH is invoicing Mr. and Mrs. James. So if you look, for example, at the top of page 5, line item 220, there's a Butler and Neo invoice 826, which is presumably Butler and Neo's invoice to RBH, but the invoice for which payment is claimed is number 491, which presumably is to Mr. and Mrs. James. And there are quite a number of these invoices referred to in the middle column,
Yes.
to which that may be the pattern.
Yes, and obviously that's one of the points of context being that it was cost reimbursable. But you can see cost to us. This is us presenting costs we've incurred under the agreement that they will be reimbursed. I don't know if the column C, where it refers to an invoice number, an invoice date, if that is talking about an invoice from RBH, or which we gave, or an invoice we received. I can try confirm over the break. Maybe it's gave, because you can see in column H that some of the figures refer to invoices. So, for example, on page 65.4, we can see the ones highlighted in blue, Sheldon Southwest. But actually, I think that would be it, that they refer to an invoice. They have an invoice, don't they? Maybe it's covered. Well, they at least have an invoice number, which is different to the one we can see in column C. But I can try and bottom out that point over the lunch.
Well, I mean, it's just, this is the document as presented.
Yes. Obviously, in an Excel format, it's slightly easier to follow than it can be printed out.
Well, it's a lot of items.
Yes, and the second...
Not even on a management contract, on a cost reimbursable basis, it's you have to do an enormous amount of legwork to work out where these sums arise, why they're due. I mean, you effectively you have to assume that they all relate to this project.
Yes, but of course...
And they had 17 days to reply.
Yeah, yes, and obviously the timing periods are set by Parliament. Just in terms of the two schedules.
Yes, they are. If you decide that you're going down the route of serving a payment notice 8 months after the work stopped in this form, then you're quite right. Parliament has laid down very strict timetable.
Yes.
If it's a payment notice.
Yes. Well, my lord, I would, just in defence of the application, of course I didn't draft the application, but I do defend it. I would say that this is presented in a clear and detailed way. What you particularly from page 72, you have all of the invoices listed in date order. So it's very clear running through. You then have a categorisation of the invoices in the previous pages, and helpfully, of course, they've each been individually listed. Now, I accept that when you first open up a payment notice and you have 10 pages, it can say, well, that's a lot. But actually, the complaint you far more often see is people saying, well, you've said 100,000 or 200,000 for X, and where's the breakdown? Where's the detail? That is what people will want to see.
So
and
what's
having the breakdown
total-
per invoice.
So what's the total for, I don't know, the swimming pool or the groundworks or finishes or foundation?
I accept those, though they're not stated in categories.
Okay, so anyway, that you accept that that's a relevant part of the context.
Yes.
The payment notice
Yes.
put forward by RBH.
Yes.
So do we then come to the payless notice?
Yes, my lord. And just for completeness, before we leave it, there is the third sheet. I mentioned 3 sheets, but the third
yeah.
sheet, page 84, is just the list of all breakdown of all payments, 84 and 85. So all payments received. So that's perhaps less. But you can see, and there is a payment allocation between suppliers and RBH's fee, and but the total sum paid was £1.310 million. So the application was for £600,000 on top.
Yes.
So then the payless notice, my lord, is supplemental bundle. At the very start of supplemental bundle, tab 1.
And hang on a minute, just so that I'm clear.
Yes.
So the 600,000 on top had not been invoiced before, because the last invoices appear to be April.
Yeah.
I think that's correct.
Must be right, mustn't it?
Yeah. Yeah.
So the payless notice is at tab 1, page 2. And in fact, that's the covering email, and the attachment is in fact called Notice of Intention to Withhold. If we go over the page 3, again you can see that the heading is Notice of Intention to Withhold Payment.
Yeah.
Which is of course in fact a reference to the unamended Act rather than the amended Act.
Do you take any point on that?
I do take a point in I don't say that I accept that the statute doesn't say you have to use a particular word or refer to the correct act, but I say I do take a point in terms of it's an overall you're considering whether this is sufficient. Both they haven't used the language, but also in my submission it shows why they then fall into error and why it's insufficient, because they seem to be trying to adopt the approach required under the old Act.
You know, of course, that, because I've said it elsewhere, that the changes to the Act I regard as completely footling and make no difference at all to the substance. And whether it's a payless notice or a withholding notice, the same purpose is there, namely to set out what you're going to pay, or if you're not going to pay, why you're not going to pay. I mean, I take the point the words are different, and I've yet to see a notice that I've thought, well, that's definitely a withholding notice, but not a payless notice,
Well, it
or
may,
the other way round.
It may be a point against you, my lord, but it may be under the unamended Act I would have a good better shot, in the sense that a clearer shot in that it does say that each ground you're meant to state the amount you withhold, and that may be a problem here on some of these grounds. But anyway, obviously that's not the point
we have the point that
yes.
It says withhold.
So it's obviously not. I don't live and die on that point. What we then have is it says we intend to withhold payment of 663 and accordingly intend to make payment of 0. And that is my first point, that I say there is a mismatch in terms of sum due and basis on which it's calculated, because in fact the submissions made to the judge down below were that the basis or the grounds for withholding were to say that 1.2 million was not due, to withhold 1.2 million. But of course it's not the language which was used. The language was to withhold payment of 663.
Because that was the claim.
Yeah.
And intend to make payment of 0.
That was the claim,
Yeah.
663.
Yes, but then you again get to look at.
I mean, they say we're not paying you anything.
Yes.
Because they say our figures show that 1.2 million isn't justified.
Well, in my submission, my lord, as I quantify, they don't go as far as saying that, because when you then look at the reasons for withholding, we obviously had the 11 bullet points. But the first point to observe is in none of these do Mr. and Mrs. James actually set forward their statement, their sum due, or what they've calculated as due.
Well, some of them are plainly nil. Take number 9, RBH is not entitled to overheads and profit.
Yes, so.
I mean, there's a number of those.
Yes.
I think I've found 6 that are insufficient evidence and 5 that are nothing.
So on the insufficient evidence, which is the 2 key points are where they refer to a figure, that effectively is a figure taken from the application. It's not their valuation. They've grouped together rows from the application. And the response is to say insufficient evidence has been presented to confirm what sum, if any, might be due. And in my submission, that is not a statement which is required, a statement from them as to, based on how they calculated it.
But if this is the first time they've seen these invoices or any claim has been made, how would they know?
Well, my lady, I do observe that their position that they've set out would be to the effect that they've overpaid by £600,000. So I think the court should, one of the contexts the court should bear in mind and approach this from is they've already paid to 1.3 million. Yeah. So when they're now saying, well, there's no evidence, and if you add them all up, it's not in there, which I say is the problem. When you add them all up, in fact, we should have only paid you 600,000. That should colour the assessment where they say there's no evidence, because of course you've made payments before.
Sorry, I'm not a construction lawyer, so you'll
Yes.
have to forgive me. What I was asking was if this is the first time that they had this notice, which we know that's the case, and so no, they have not been asked for repayment of any of these monies up until now. How would they know?
Well,
How would they have sufficient evidence on the basis of those schedules that money was actually due?
Well, the statute, obviously, Parliament puts an obligation on the employer. The employer has to state the sum they consider due. The employer has to have regard to that obligation. They must be having their own valuations, assessments. They can't just rely on what
in the 17 days they should have gone through all of this and got their own itemised assessments. Presumably, were they, just help me how this works?
Yes.
Please forgive me for being slow.
Yes.
Together with the schedules, would they have been given copies of all these invoices?
I'll find.
I'm sorry, there's lots of no's on the other side, so can I just work on the basis they're right for a moment, and you'll correct me?
They may.
So again,
Yes.
how were they? If this was the first time they saw these invoices, saw the schedule.
Well,
they had 17 days, and they weren't given the actual invoices, which presumably would have some sort of breakdown. How on earth were they supposed to provide a counter figure?
Well, my lady, in my submission, the approach which should have been adopted in that case would have been to gone through and say, on each line item, we haven't had that invoice. haven't had that invoice, haven't had that invoice. That would have been the correct approach, because then the parties would know, okay, so it's these specific...
Is that how it's usually done?
A lot of contracts aren't cost reimbursable, and therefore obviously the fact of an invoice is less important. It's more, often it would be you've done 100% of the work, and the agreed value, say if the activity schedule for that work was X, and the other side say, no, we think you've done 80%, so we'll value it less. But in my submission, that would have been what Parliament would have intended to stop this approach of just saying generally, no, we don't accept this. Would have been
they don't say generally no. They identify specifically various items, various subcontractors, where they say that there is insufficient evidence. It's not all of them. So Hanson, which is a name that crops up quite a lot, it isn't there. I think contract welding. Oh no, contract welding is there. So they've clearly been through and identified, had to gather together the correct invoices under the various heads, and they've said for 6 of them, they've said, well, there's insufficient evidence as to confirm what they might be due.
Yes, insufficient evidence. What sum, if any?
Yeah.
But my submission
So they're putting the burden of proof onto the contractor.
But the Parliament intended to make sure that the
Parliament did not intend smash and grab. Sorry to use the expression, but Parliament didn't intend that. Parliament intended to prevent subcontractors not being paid by trumped up counterclaims, defences and counterclaims, coming along at the last minute. But they didn't intend to create a gaming system. There should have been discussions.
Well, my lord, in my submission, the requirements to state the sum due.
Yeah. Well, they say if any, so we can read into that. At the moment, 0.
Well, as I say, in my submission, that's insufficient. They need to be more precise, particularly in the context of the application they've received and the nature of this contract. And also, you have the problem then of the mismatch between the figures. The valuations they pick out are only 295,000. Of course, if you include the valuations for the other items where there's no figure, that's where you get to the 1.2 million. And therefore, are they saying they're deducting 1.2 million, and therefore that gross valuation is less than being paid, or are they saying the gross valuation is the exact sum we previously paid for?
And that's why there's a lack. They're just telling you you're not entitled to any money.
Well, as I say, my lord, in my submission, this notice does not provide adequate statement of the basis on which the sum due, to provide an adequate agenda for an adjudication, which is obviously one way it's been approached.
Can you just help me on the maths? The 5 items where they're saying is therefore not due. So 3, 4, 9, 10 and 11, is that right? In other words, the 5 items that aren't the insufficient evidence point.
Yes, my lord.
And those come to what?
There's it was a helpful table which my learned friend had in his skeleton argument, which is in the judgment, page 74. We'll probably need to do a little bit of...
74.
Page 74 of the, paragraph 53, page 74 of the supplementary manual. sorry, the core bundle.
Thank you.
Let me just pick out then the.
Yes, I've got the table.
Yes, I just need to
Which
pick
is
out
very-
the figures. The
and
line items you've referred to, my lord.
Yes, now I've got the table and I think that we certainly, I understand your submissions on the insufficient evidence items, and I think there are 6 of those out of these 11. And I think the remaining 5, I think, are 3, 4, 9, 10 and 11.
Yes.
And I just wondered if anybody had added those up.
My lord, I get to £564,774.
Those 5.
For those 5 items, assuming the figures in my learned friends table are correct, which I think I should check at the time, and I have no reason to doubt them.
Matt, say that again. 500.
564,774 and 8 pence if anyone's counting the pence.
That's very helpful. Thank you very much.
Of course, in my submission, you must consider the notice as a whole, and it shouldn't be a case of is one element partially sufficient, but considered as a whole, does it adequately set out the basis on which the sum is due? And that's why I say it does not. If there are any other points which I can particularly assist the court with, I'm happy to take you to them. I think that probably covers the points I wanted to make. Ultimately, as I said in opening, these rather falls on one document really on the first issue and 2 on the second. I may have taken those documents at quite some length, but hopefully it's been helpful for the court.
It's been most helpful to go through them, and of course we've got the benefit of your skeleton argument
Yes.
as well. We're just going to rise for 5 minutes, please. Yes, thank you, Mr. Hannah. We'd like your detailed submissions about jurisdiction. We don't need you to address us on payless.
Well, again, I'm very grateful for that. I'm looking at the clock, my lady and my lords. I'm not entirely sure I'll finish before lunch. I'm entirely in the court's hands. I'm conscious that my learned friend trimmed his sails a little bit this morning compared with the written submissions. Not a criticism, but it did occur to me that I might also be able to trim my sails and get through jurisdiction slightly quicker if the court was minded to take an early luncheon break. But as I emphasise, I'm entirely in the court's hands.
No, I think given it's only 12:10, we'll risk you tipping over into lunch. After all, we did allocate a day.
I'm grateful.
And I do hope Mr. Frampton didn't feel he'd had to trim his sails too much. We felt conscious.
I made the best that I could of the wind, so... Yeah.
Well, I should point out in Mr. Frampton's defence, he said he thought he'd be finished by around 12 o'clock.
And it was 12.
And it was bang on 12. So I have to say, I noted that down in my notebook. So, Mr. Hannah, the pressure's on you.
That's quite all right, Lord. I think it's possible that I'll get through my submissions entirely then.
Please don't feel under pressure.
I'm grateful.
And of course, we'll be back, no doubt, anyway, because of course, Mr. Frampton must have an opportunity to reply.
I'm conscious of addressing, first of all, Lord Justice Coulson's question about the demolition of the prior building. And the answer to that question was, in fact, before the judge at first instance, and that is because the answer appeared in a witness statement from Mr. James that was prepared for the purposes of the adjudication. And that was in the first instance bundle. It doesn't appear in the appellate bundle, my lord. The answer given by Mr. James in that evidence is that prior to demolishing the existing property on the Ferndown land, they did live in that existing property as a second home, and that was before they relocated to the property in Devon in January 2022, and it was around that time that the demolition was taking place. As to Lord Justice Coulson's question about whether demolition works were performed by RBH, my client's understanding today is they were not procured through RBH. RBH may have certainly overseen them in its management role.
Okay, so yes, which is what the contract originally was about, management. So the original or the early management fees were being incurred in respect of the management or supervision of the demolition.
In part, is my understanding.
Yeah, that's good. Thank you.
With that introduction, what I propose to do is take my submissions in jurisdiction in 4 parts, as follows. First, the law. Secondly, the relevant facts that are before the court. And I'm conscious of getting through that quickly because the court has already indicated being through the factual evidence in some detail. Thirdly, then I'll deal with RBH's primary argument, which are the terms of the development loan. And fourthly and briefly, I will wrap up in relation to the Airbnb point, if I can put it that way.
Thank you.
I'll begin by saying a few words about the law. And the starting point, my lady and my lords, is that this is an application for summary judgment. And I listened quite carefully to my friend's submissions this morning. I'm not entirely sure the word summary judgment was ever mentioned, but what I do know for sure is that the test for summary judgment was never mentioned. And we said it's important because the magic words of summary judgment were never said. And it doesn't seem to have been positively asserted by RBH this morning that it can satisfy the magic words in that test in CPR Part 24. And in this particular case, what that would require from RBH in this appeal is to say that my clients, the Jameses, have no realistic prospect of making good at trial their argument that they intended to live in the house as residential occupiers.
Well, the words may not have been used, but that was the effect of the argument that the terms of the development loan effectively trump everything else as a matter of law. And if that's right, then you don't have a real prospect.
Lord, yes, and I'll come on to that in a moment for certainly. It's merely an observation that, I'll put it this way, perhaps RBH has certainly shied away from that test in its submissions today. The relevant principles for summary judgment, this court will be very familiar with those. They're summarised in paragraphs 22 to 24 of my skeleton. I won't repeat those, but for present purposes we would emphasise 4 points. First, the test, as I mentioned a moment ago, all that the respondent to a summary judgment application need establish is a realistic as opposed to fanciful prospect of defending the claim. Secondly, the fact that this was a claim to enforce an adjudicator's decision does not affect that analysis. The threshold that a claimant in RBH's position must meet in order to obtain summary judgment under Part 24 is not in any way watered down because it so happens that this claim is the subject of adjudication business. Thirdly, in an application for summary judgment, it is not open to the court as a matter of law, to reject the respondent's witness evidence unless that evidence is manifestly incredible. And that's the test, as I explained in my skeleton in paragraph 24. That's a test that comes from the dictum of Lord Justice Reimer in Coyne and DRD, and has been approved by the Supreme Court in Griffiths and Toohey. And fourthly, and relatedly, insofar as there are disputed issues of fact in a summary judgment application, the court cannot conduct a mini trial to adjudicate upon those factual disputes. Instead, a respondent with a prima facie defence is entitled to take its case to trial. So we say that those are the key elements of law in relation to summary judgment. I'll say a few words next, if I may, about section 106 of the Act. As RBH already noted this morning, there are only a small number of cases that discuss that provision, and for the purpose of this appeal, unfortunately, few, if any of them, are of any direct relevance. But there is a large measure of agreement between the parties about the approach to be taken in section 106 cases. First, the intention is to be judged objectively, relying upon the factual evidence. Now, I'm conscious that my Lady Justice King and my Lord Justice Males had a question earlier on this morning about the subjective element. I'll come back to that in a moment, if I may. There is assistance in the authorities on that. But secondly, the time when the building contract is entered into is particularly important when assessing intention. Thirdly, as a qualification to that, the court may look at evidence of intention before and after the contract date in order to test the intention at the time of contracting. And fourthly, and as it was put by the court in the Westfields case, above all, the issue is to be approached as a matter of common sense. Now, if I may, on the subjective point, I mentioned there was some assistance at an appellate level. It is assistance in relation to a different act, and that is the 1954 Landlord and Tenant Act. Why I say that might be of assistance to the court is because of the very close similarity between the words. And I can show that to the court very briefly, if I may. The relevant provision in the Landlord and Tenant Act appears in the Authorities Bundle. It's tab 3, page 20. Just by way of an overview, this is it's an older provision, but it's a provision that's still in force, and it allows a landlord to object to an extension of a tenancy on certain specified grounds. So it's the situation where the tenant wishes to extend. The landlord says, "I'm not going to let you," and these are the grounds on which they're allowed to reject that request. The relevant one appears over leaf, section 30. Subsection 1, and on page 21 over leaf we see paragraph G, around halfway down the page, and the ground for the landlord rejecting the extension, this ground, is that they intend to occupy the holding for the purposes, or partly for the purposes, of a business to be carried on by him therein, or as his residence. And so we say there's a close similarity between those words. Occupy, it intends to occupy as his residence, and the words we see in parallel in section 106 of the Act with which we are concerned.
What the 1954 Act has, which our Act doesn't, is a temporal point, that is, on the termination of the current tenancy, whereas there's nothing about that in the Adjudication Act. What do you say about that?
Well, your Lordship is quite right. In terms of the express wording of the statute, the 1954 Act has a temporal express restriction. Section 106 does not. But as I said a moment ago, the authorities on Section 106 have been clear in this regard, which is that intention is to be assessed primarily at the date of contracting, albeit, as I mentioned a moment ago, the court may look around that time period to test the intention at the time of contracting. And the reason why the intention at the time of contracting is so important, my lord, is because the question before the court is this building contract a building contract to which the Housing Grants Act applies or not? Is it an exempted building contract? And that's why the court's focus is drawn upon the contract. And we say, and the authorities have said, intention at the time of contract is therefore crucial.
Yes, well, I understand that. I understand that the points that you're on are that there is, at any rate, an objective element to intention, and that you get that from the cases under the 1954 Act, Gregson in particular, and cases which have followed it. But I'm just wondering if you could deal in due course with what you say, or whether you say there is any temporal limitation inherent in the Act that we're concerned with. So for example, an example occurred to me is that a young man buys a house by the seaside, which he then enters into a construction contract to do it up, and what he intends to do is that he'll let it out for holidaymakers, but he has an intention which is genuine, and he can prove it, that in 30 years' time, when he retires, he'll go and live in it by the seaside. So he does intend to reside there, but it would seem rather strange if that was the kind of intention which the Act is talking about. So I'd like to know what you say about any temporal element in our Act.
Well, Lord, I understand the point now. The reason why there must be some horizon point on temporality is to avoid the following difficulty. The difficulty that if intention changes over the course of the building contract, that the Act may be applicable, then inapplicable, and perhaps applicable again, depending on how intention is varying over time. That's something that it's never been suggested in any of the authorities that it works like that. And there are good. It's not suggested by RBH today, and there are good reasons to think that was absolutely not intended by Parliament, because it's crucial at any point. I'm so sorry.
I wasn't putting to you a case where somebody's intention changes. He has a fixed intention, which doesn't change, that he's going to retire there in 30 years' time.
Lord, I think the Gregson Line of Authority assists us in that regard. It's and if I might, perhaps the easiest thing to do is to take the court to the best summary of that. It appears in the Gatwick parking case. It's at tab 9 of the authorities bundle. And this is the judgment of Lord Justice Laws in that case, giving the judgment for the court. Page 76 provides a summary of the appellate authorities up until that point. At section B, it's sort of the intention is not a purely subjective one. That his lordship goes on to quote from Gregson, and it seems to me the key portion is halfway through that quote from Gregson. In my judgment, it is essentially an objective test. That is to say, would a reasonable man, on the evidence before him, believe that he had a reasonable prospect of being able to bring about his occupation by his own active volition? And that's to be determined on the evidence before the court. And Lord Justice Laws goes on to quote Cadigan, another Court of Appeal case, that says reasonable prospect means a real chance as opposed to fanciful. And it means, to answer my Lord Justice Mill's question, it means that the prospect of actually occupying must be judged at the time the matter comes before the court on the objective evidence as it exists at that time, to assess whether the prospect of occupying is reasonable. I'm conscious you...
Isn't that the second part of a test? Isn't that stage 2? Isn't stage 1, picking up my my lord, is what was the genuine intention? So stage one is subjectively, did they really intend to live there? And but to make that good, you've got to have the objective aspect of it. Did they have a reasonable prospect of making that happen?
My lady is quite right. The Gregson Line of Authority makes clear it's a two-part test. The first is whether the prospective occupier's intention is bona fide.
Yes. And
the second is whether it can be reasonably brought into fruition. I might test it in a different way by giving a different sort of ad absurdum argument. I might commission a builder to repaint the gates on Buckingham Palace. Now, if I cancelled that contract a couple of days later, had paid nothing, but sought to claim the residential occupier exception to the Housing Grants Act, the point would be made against me quite rightly that no reasonable person would have thought that I had any reasonable prospect of, whatever my intentions were or how mad I might have been, I had no reasonable prospect of bringing that occupation into fruition. It wasn't going to happen. In my answering my Lord's question, factually that might be a more difficult case to make out, in the sense that the occupier there is saying, well, when I retire in the future, in 30 years' time, I'd like to live there. Ultimately, it would be assessed on the facts. And a relevant fact would be that this person would have been paying for works to that house. There would have been questions about whether between year 0 and year 30, for example, did he intend on the facts to let it out for a full 30 years before occupying? Well, in that case, it would be said against him that it isn't really that you're intended to occupy. It's really being done to be let out. And the prospect of occupying in 30 years' time is such a small scintilla of reality in the far-off distance that it doesn't count sufficiently for you today. But that may be the best I could do to answer my Lord's question, which is a tricky one. But I have to say, far removed from the present facts.
Well, obviously, but I'm trying to understand what intends means. That's all.
Well, it might be that my Lord's example falls on both stages of the test. On the subjective first stage, the bona fide is, well, you know, a pipe dream is not enough. And in any event, on the second objective, showing that it was a reasonable prospect, well, you know, the vagaries of life, how can you possibly be satisfied on an objective basis that in 30 years' time they'll be able to do that? So it seems to me that you might fail on both bits.
But my lady, I see that, and to think
that's where the temporal bit might come in.
Quite, and to think about it, perhaps applying the sort of approach that was applied by the Court of First Instance in Westfields. It may be, if the evidence was, I wish to let this out for many years and eventually retire it, that is sufficiently suspicious in intent that the bona fide nature of the part of the test is failed. Because it might be the right conclusion on the evidence there is that isn't true, and in fact the intention is to let it out long term as a business prospect.
Well, it might be, but I was putting to you a case where the judge believes the witness.
Well, if
obviously if the judge does believe the witness, then don't need to
in,
worry.
I suppose in that sense it does make it easier. If on the facts, objectively, the judge has reached the conclusion that they genuinely intended to live there eventually, and that there was a reasonable prospect of that happening, that they were building their far future retirement home, well, we would say no policy reason why Parliament wouldn't have intended that person to be protected by the Act, because at the heart of Parliament's policy decision, and it was a policy decision in Section 106, is to protect from the stringencies of the Housing Grants Act individual homeowners, and the reasons for that are, as the court will appreciate by now, the Housing Grant Act imposes a stringent payment regime of making applications, responding to applications, with draconian financial penalties, potentially, if that regime is not implemented. And in a sense, coming back to the court's questions a little earlier this morning about how the Jameses would have been expected to carry out an assessment of that payment in 17 days, in a commercial context, that wouldn't be a problem, because in a commercial context, ordinarily, the employer to the building contract will have one, and sometimes many, staff on hand, either its own employed staff or third-party consultants, to assist it with specifically to assist it with assessing payment applications. In particular, someone who might be qualified as a quantity surveyor. And so, in an ordinary case to which the Act does apply, responding in 17 days isn't a problem. It shouldn't be. But for homeowners, it would be. Particularly in this instance, Mr. and Mrs. James confronted with this payment application for the first time. No such applications had been made previously. No build-up in correspondence to assert this claim. It came out of the blue. And the difficulties that presented for them in having to scrutinise that from scratch, in having to take legal advice within 17 days are exactly the sort of thing that Parliament did not intend to impose upon individual homeowner residents. I hope that has assisted.
Thank you. Yes.
I began by saying there's a good deal of agreement between the parties in relation to the law in section 106. Where the parties start to part company is over the Howson and Redfern case, which is the case in which the court held that the defendants were not section 106 occupiers because they were in flagrant breach of planning laws and specifically planning conditions. Now, RBH's case is that Howson case is relevant or analogous because the James's occupation would also have been quote-unquote unlawful because it would have breached the loan agreements. I'll have a little more to say about the loan agreements a little later, but I want to address RBH's argument on Howson's as a matter of law with 4 points, if I may. First, the Howson case was a very different case because the unlawfulness with which it was concerned was a breach of planning laws. And that's important because not only do planning laws exist for the public good, but breach of them can attract penalties, including criminal penalties. By contrast, the alleged unlawfulness in this case would consist at most, as a matter of private law, a breach of contract, which could be waived by the counterparty, and which in any case would only ever sound in damages. And we'll come on a little later to look at whether it was indeed waived by the lenders.
Well, Gregson was also concerned with the breach of planning law, and the people concerned were the landlords were held to have the intention to use the property as their own business or residence, even though they might be in breach of planning laws, if there was a reasonable probability that there would never be enforcement of those laws,
Yes.
or if they could get effectively a retrospective waiver. So there was the intention to do something which might well be unlawful, but didn't stop them having the intention. But how does that fit with Howson's?
That is the point, my lord. We say that the Gregson line of authority is the way to unlock an explanation of Howson's. Howson's a case on the facts ultimately, but the difference between it and the Gregson line is this. As a matter of fact, on the planning documentary evidence before the judge in Howson's, the judge found not only that was it a breach of the planning conditions, but also the local authority would not grant the change of use. Or I'll put that a little bit differently, would not consent to the breach of the planning conditions. And that is because the the occupiers in houses did exactly the thing that the local planning policy forbade, which was to convert, by subterfuge, to convert local and agricultural buildings, which the planning authority wanted to maintain for economic purposes and cultural purposes, to convert that into a house. And in their planning application, they said they weren't doing it. That was always going to be untrue because that was their intent. And the judge found that the policies of the council indicated they would not consent to that. And that's the difference, Lord, between that case and the Gregson. It can be reconciled. It can be reconciled applying the Gregson approach, because Gregson invites the court to consider whether there was a realistic prospect of the intended occupier giving effect to his intention of being able to occupy lawfully and peaceably. And the judge in Houston said, well, no, that your occupation would always be under a cloud. It was unlawful from the very start. When you sought planning permission, you lied. When you placed the building contract, it was to convert the barn in a way that was not permitted. And that would always be the case. The unlawfulness there was inextricably bound up with their occupation. Whereas Gregson recognised the possibility that a landlord reoccupying their business, even if they don't have planning permission right now, they might get it in due course. And that's to be assessed prospectively on an objective basis.
So that the difference is in Housens there was no realistic prospect of no enforcement or a retrospective order.
Lord, yes.
On the contrary, it was a no-no.
Lord, yes.
But it doesn't look as if the Gregson line of cases was cited in Housens.
My lord, if I may, I was involved in Housens.
Yeah, I was going to say,
there was no reference to the Landlord and Tenant Act or any other cases.
Thank you very much.
I'm grateful. So that's my first point on Section 106. There's a difference in character between the so-called unlawfulness here and the unlawfulness that was at issue in Housens. Secondly, we say that Section 106 does not require the residential occupier to be residing in a manner that complies with all contractual obligations that it may have. We say that's reading into the statute words that simply aren't there. The words of the statute are occupies or intends to occupy as his residence. It's a simple phrase, it's clearly expressed, and there's nothing there that would invite the court to read into that a qualification that the occupation must not also involve a breach of contract. And one way of testing the point as a matter of statutory interpretation would be to ask why Parliament would have intended that implied requirement to exist. Why would Parliament have wanted to insist that to take advantage of the Section 106 exemption, you must be occupying your house without any breach of contract on your part? And that in turn drives one to ask what is the purpose of Section 106, or put differently, what is the mischief at which it was directed? And at the risk of repeating myself and what I said a few moments ago, we say the answer to that is clear. Section 106 is there to relieve domestic occupiers, residential occupiers, from the stringencies of the Housing Grant Act that would otherwise apply. Their policy, it was a policy decision that people living in domestic buildings should not have to be concerned with that act. And as far as that objective is concerned, the objective of exempting homeowners from the act, that objective is not in any way furthered by adding or reading in a requirement that the homeowner must be occupying consistently with all contractual obligations it may have. There's a different way of putting it. There's no reason to think that Parliament only intended to protect residential occupiers who keep their contracts and not those who don't. Thirdly, the Jameses in this case do not have to in any way rely on the breach of contract to show that they are occupiers. And that's different. I'll explain what I mean by that. That's different from the Housens case. As I said a few moments ago, the nature of the facts in Howson's was that, so it was such that the occupier, from start to finish, their intention was tainted with illegality. They intended to do something they knew was unallowed, which they didn't get planning permission, and for which they would never get planning permission. So whenever they appeared before the court saying, I'm occupying these premises, that was necessarily and inextricably tainted with illegality, because their occupation was itself a breach of law. That's not the case. I'll develop this a little later on. That's not the case here, because our evidence is that we were never going to occupy the building in breach of the loan obligations. The plan, and it was a reasonable plan and a realistic one, was to clear the loans before occupying. For that reason, our occupations would never be tainted with illegality, if it is even appropriate to characterise breach of contract as illegality. And fourthly, if Section 106 occupation were to involve a requirement that there be no breach of contract entailed in that occupation, that would we say, be liable to create real mischief in the real world. As my Lord Justice Coulson noted earlier on this morning, there may be quite a few situations in which a normal residential occupier finds themselves in breach of a contract, most obviously their mortgage contract, because mortgages come with all sorts of restrictions, terms that the homeowners should not leave their house for any more than 30 days at a time. Well, that could be breached by a long holiday, or a sabbatical, or perhaps moving out of the house while the builders demolish the kitchen. There are terms preventing owners from taking in lodgers in a normal mortgage. There are obligations in a mortgage, typically, to notify the lender before any building works commence to the house. Now, we would say that up and down the country it's possible, it's more than possible, it's likely, we would say, that those sort of mortgage terms are breached on a day-to-day basis, perhaps more often through ignorance than through deliberate intent. But it will happen. And if RBH's case is right, that would mean that all those residential occupiers, unbeknownst to them, lose the benefit of the Section 106 exemption. But more than that, it creates a mischief by opening the door to claimant builders like RBH to go scrabbling around in the homeowner's legal affairs to identify some respect or other in which the homeowner, the resident, was in breach of a contractual obligation, and to use that as a keyhole to unpick the Section 106 exemption. And we say that that can't be what Parliament intended by the Section 106 exemption, and it would fly in the face of the common sense approach to the residential occupier exception that pervades the authorities. And the present case is a good example of the claimant scrabbling around for some way to work around the exemption, because as was acknowledged this morning, RBH was not aware of the contract at the time. It never saw it, and indeed it wasn't aware of the existence or terms of the contract at the time when it adjudicated, or even at the time when it first launched these court proceedings. It's come into it quite by chance. So, my lords and my lady, that's why we say approaching the Section 106 exemption in the way that RBH invites you to do would open the door to considerable mischief in the real world. Those are submissions in the law. I'd like to say now a few words about the facts in general. We say that those facts are important. It may, of course, be a little bit unusual to come before this court and say that facts are important. But first, this is, after all, an application for summary judgment. And we say that the defendants, the respondents' factual defences will necessarily be quite important in an application of that type. Secondly, the learned judge, of course, found the facts were crucial to his decision. And thirdly, in our submission, the outcome of this appeal also inextricably involves and relies upon the facts. And we say that the arguments that RBH has made this morning are, properly understood, arguments about facts and not about law. There was quite a bit of witness evidence produced for this application, and it was included in the bundles for the appeal. There are 2 witness statements from Mr. Huntley, 3
We can take it that any relevant facts are summarised in the judgment. It's not for us to wade through 8 statements, is it?
My lord, no.
There's no appeal against. The appeal is clearly set out. It's not saying the judge was wrong to find X as a fact or to refer to Y as a fact.
Well, quite rightly. Well, in that sense, maybe I can cut through things by relying upon.
Well, I mean, if I'm not anxious, just as I was with Mr. Hampton, not to cut off any submissions that you want to make, but we're not really here to trawl through facts that the judge has already addressed.
Well, I'm grateful for that, Lord. The reason why I thought it might assist the court, and I certainly wasn't proposing to trawl paragraph by paragraph or page by page through the witness evidence. I'm very conscious the court will not be assisted by that, but I was going to highlight some key facts. The reason I thought it might assist the court is that because this is an appeal from an application for summary judgment, and because the court below made no findings of fact, this court is in the same position as a learned judge found himself at first instance, and equally is being invited.
So what are your highlights?
Well, I'll give those now, my lord. First of all, and as I go through, if it assists the court, but by all means, please do tell me if it doesn't assist. I'm happy to give some references to the bundle.
That's helpful. Yep. Always like a reference to the bundle.
Without taking the court to it, what I would say is the starting point is Mr. and Mrs. James are both clear and unequivocal in their witness evidence that they intended this to be their home. That was the evidence at first instance, but more than that, it was also the evidence that was given during the adjudication itself, because the residential occupier question was before the adjudicator. Mr. James's first statement, section 3, explains the background to the project. They lived in Essex, but from 2015 onwards they developed a wish to move to Devon. They looked at a number of properties down there over a number of years. They eventually settled on this one because, in Mr. James's words, Ferndown was perfect. And what he explains in section 3 of his statement is that there were a number of idiosyncratic features that were perfect for him and his wife. I won't go into all of them now, because I can't do them all justice. The sorts of things he had in mind are, was there a train station nearby so Mrs. James could occasionally commute into the office? Were there paths where they could walk the dogs without crossing a busy road? Was there a beach nearby? And the beach was particularly important to him, as he explains in his evidence, because he aspired to start a kite surfing school on the beach. And more than that, he gives evidence that he'd already begun some discussions with a Mr. Christie, who was the owner of the beach. And he also gives evidence that there used to be, and this is page 14 in the supplemental bundle, he gives evidence that in fact he knew there used to be a kite surfing school on that beach, but the teacher had passed away. Now, the point's made against Mr. James that he's a property developer by background. He doesn't shy away from that. That's a business run by his wider family, including his brother. But his evidence is that his family business operates in Essex and London and has never developed housing in the southwest of England. And more than that, in section 1 of his statement that begins on page 12 of the bundle, he says that this project would have made no sense as a commercial development. The land was purchased for £2 million, and the evidence of that is page 261 in the bundle. And the build costs were expected to be around £4 million, and the court will see the loans taken out were in excess of £4 million in total. And at that total cost of £6.5 million, this wasn't going to be a viable commercial proposal, he says, because the profit would have been limited, if any. He also explains in section 1 of his first statement that he's never developed a property in his own name before, and doing so would be very commercially unusual because developers use companies or very often SPVs. But what happened here was everything was done through individuals. The land was registered in Mrs. James's name. The building contract, of course, was between RBH and the husband and wife as individuals. Mr. and Mrs. James are named personally on the loan agreements, and some suppliers and subcontractors.
There's also a company, isn't there?
I'm sorry.
There is also a company which is a part of.
There is. I will count. Well, I'll answer my Lord's question on that now. The reason, and I'll explain this later on. The reason why the company is named is because the company was putting up collateral. It's a family company. There are two properties that were charged under the loan. The first is Ferndown, this property. The second is known as Oakview Lodge. Oakview Lodge was owned by Casec Limited, the company. And the reason why that second property was needed as collateral was because Ferndown was not sufficient collateral. It was bought for 2 million and the loan was 3.7, I believe. That's the reason why Casec named the Lord as a second borrower. Some suppliers and contractors were also personally engaged by the Jameses, and that can be seen in some sample invoices that appear in the bundle at pages 87 to 98. What else, we say, indicates residential occupation? Well, the Jameses when they bought this house this property in 2019, they paid the surcharge for a second residential home. And not only that, but they later reclaimed that when they sold their prior house in Essex. And the stamp duty documents are in the bundle. They're pages 255 to 266. They sold up their house in Essex and they moved to Devon in January 2022. And from that point until November 2023, they lived on site in a caravan. And that's explained in Mr. James's first statement at paragraph 7.1 and 8.9. And the only reason they left site in November 2023 was because landscaping works had to take place, and so they had to up sticks with the caravan. Since then, they've been renting modest accommodation locally. They register with the local GP, they register on the local electoral register, and that can be seen in paragraph 8.9 of Mr. James's first statement. And I can go on, but I need not. There's evidence about friends they've made, WhatsApp texts, and perhaps most tellingly of all, contemporaneous evidence of emails. It's in the bundle. Emails between Mr. James and his lawyers, in which he takes legal advice, including from counsel, and the advice is disclosed in the bundle. Advice from counsel about a restrictive covenant on the land that he was worried might impede what are described as short-term Airbnb lets. And the advice from counsel was that an injunction wasn't something to worry about in the end. But that appears, I'll give the reference for it, it's in the supplemental bundle at page 48 and 49, and also later in the bundle, pages 116 and 117, exchanges with an insurance broker about getting insurance for, again, short-term Airbnb lets of the property. The question, of course, the court might ask was, well, if that's all the case, why aren't they living in the property? And the answer to that is that, as the old saying goes, even the best plans of mice and men go awry. It's explained in Mr. James's statement in the supplemental bundle, tab 3, it's page 19, paragraphs 8.16 to 8.23. The simple answer is that COVID and then the Ukraine war caused interest rates to skyrocket from essentially 0 to 5.25%. And at that level, the Jameses simply and unfortunately could not maintain the mortgage. In fact, he gives evidence that even if they had let the house out all year round, at that point it still would not have paid the mortgage. And that is why they regrettably formed the view eventually they would have to sell it. It was marketed in 2025 for $6.5 million. It did not sell. It is currently still on sale at $5.5 million. It has not sold. And as my learned friend noted quite rightly this morning, the Jameses have never taken up occupation of the house. That's not, we say, because they didn't intend to live in it. It's for two reasons. One, well, it is best to sell a new built house unoccupied, never occupied. And secondly, the loans, of which we've heard so much today already, have not been discharged. Of course, the house now being financially underwater, the lenders would be no doubt very keen that the Jameses do not begin to occupy it, because they would, if it came to it, they would be harder to dislodge. And I'll note only in passing that, of course, the evidence before the court is not simply confined to the Jameses. There's also a statement from their architect for the project, Mr. Plant, and that appears in the supplemental bundle. It's tab 6 at page 127. He makes a couple of points. He says that he understood it was their intention to live there. He notes that when he sent them his contractual appointment, he selected and used the terms that he uses for domestic builds or domestic clients. And thirdly, he notes that the design of the building incorporated a lot of personal specification for the Jameses, including a lap pool for Mr. James's Ironman competition training. That's the James's evidence. RBH has never been entirely clear about what they say the intention was. They say what the intention isn't, that we weren't intending to live there, but it isn't clear what their case is on what was meant to happen to the building. There is no suggestion in Mr. Huntley, RBH's evidence, no suggestion whatsoever that this was being built for sale. On the contrary, Mr. Huntley's second witness statement, and the reference is supplemental bundle, tab 7, page 136, and it's paragraph 16 of his statement. Actually, I may break my own rule, if I may, for a moment, and take the court very briefly to that, because it is only a single paragraph. It's page 136 of the bundle.
Paragraph.
Paragraph 16, he begins by quoting from Mr. James's evidence. And that's discussing a point, an item that actually featured in the payment application. The payment application, one of the items sought was money that was said to be a bonus based on rental income. And what Mr. Huntley is saying here is, this is right, and supported in my view at the time that this was intended as a development property and not as self-build. Mr. James told me that the rental income would be received from renting the property out as an Airbnb-style house. Now, what we say about that is that that's actually consistent with the James's case, because the idea of letting out on Airbnb is necessarily short lets. If someone were wanting to let the house out for months at a time or years at a time, it wouldn't be done via Airbnb. It would be done by placing formal short-term leasehold agreements. And the question then is, which it hasn't been answered by RBH, if it were right, and it seems to be Mr. Huntley's understanding at the time as well, if it were right that we were going to be letting out this house on Airbnb, which we did intend to do, what was going to happen to the house the rest of the time? And we say it cannot seriously be suggested that a £6.5 million house, that being the acquisition cost, would be let out short Airbnb lets on holiday seasons and then left unoccupied at the rest of the year. We said that it's uneconomic, it makes no sense.
Is that a convenient moment? Is that a convenient moment?
It is. I was about to move on to the development loan, so
Well,
it is very convenient, my lady, yes.
Thank you very much. Well, 2 o'clock, please.